Dear students, let us start the discussion on today's newspaper, that is 25th August 2017. Now, the first article, privacy is a fundamental right, declared Supreme Court. This is the real festival gift given to the citizens of India by the Supreme Court. And it is a unanimous judgment given by all the judges, 9 judges bench together. So, the Supreme Court has clearly stated that the right to privacy is integral to right to life and liberty. And the second is, it has stated that it's a natural and inalienable right of the human beings. It cannot be separated from them. Constitution has just recognized it explicitly. So, the right to privacy being part of the human dignity is an inalienable natural right of the individual. And second part is, there are economic rights which are given to the people. So government giving certain economic benefits cannot be a reason for the government to take away their civil and political rights. Now, recently government has made Aadhaar mandatory for various benefits the government is providing for. If a student has to get the scholarship, he shall have an Aadhaar. So in this context, the court opined that providing for economic benefits cannot be a reason for a citizen to forego the civil and political rights. And right to privacy being a part of Article 21, it is a political right. And the second is, another point is, the right to privacy is not an absolute right. It means government can introduce laws which to protect the legitimate state reasons for and also for public interest to limit the right to privacy. It means tomorrow government makes certain law which may intrude into the privacy, stating that there is a valid public reason for it. Then the reason can be challenged in the Supreme Court under Article 32, High Court under Article 226 of the Constitution. It means you get a legal remedy which you get for the fundamental rights. And right to life also has another facet, right to privacy has another facet in the digital era, that is called information privacy. So what is this? Today information privacy is not just against the government, it is also necessary against the private companies. Big MNCs such as Google, Apple, they have abundant of the private information of the citizens. So there has to be some caution in managing and making this information accessible. And the second is, the present judgment has a significance on the other side. One is global significance and also significance for the section 377 of Indian Penal Code. What is global significance? Right to privacy is a settled matter in the international law. Now, it is as per the Human Rights Convention, as per the International Covenant on Civil and Political Rights, right to privacy is integral to this. It means the state shall not interfere with one's privacy, family, home, correspondence, honor and reputation. This is what is the established international practice. Now India also has come in alignment with this international practice. Coming to the section 377 of IPC, it prohibits any of the unnatural act. So homosexuality is prohibited under section 377. In this case, Delhi High Court in Nalsa case, it has declared section 377 as unconstitutional, violative of Article 14 of the Constitution. On the other hand, the Supreme Court has struck down the High Court judgment. Now, as right to privacy is considered to be a fundamental right, what happens within the confines of the home, it cannot be, or what happens in the confines of the four walls cannot be a question to the state. It means section 377 can also be declared as invalid under this particular law. These are the points which we need to remember. And then coming to the editorial page, endgame for section 377, already I have explained this. Now, if you see the triple talaq judgment, it has been clearly stated that religion cannot be a basis towards judging the constitution, or else There are different arguments put forward by various judgments, but finally what we can say is Section 377 has its origins with regard to the Christian religion. And most of the countries which are following the Christianity, they also have done with those provisions. In India, we are still continuing as part of IPC, and Supreme Court, as per the right to privacy judgment, clearly stated that yes, Section 377 can be invalidated. But however, Section 377 has to be invalidated not on the ground of right to privacy, but shall be on the ground of right to equality. Equality before law. Under this, it has to be invalidated. That can be a strong premise. That is what this article talks about. How the numbers compute. It is again triple talaq. Different judges have expressed different opinions, but they have missed the broader point over here. That's what it tries to explain. So, Article 25 of the Constitution, it provides for freedom to profess, practice and propagate a religion. So, in these circumstances, the triple talaq, is it a protected practice under Article 25 of the Constitution? And second, why it was invalidated? The reasons which are stated are, one is, the personal laws, the Shariat Act of 1937 is a codified personal law. A codified personal law can be subjected to the constitutional scrutiny. Because of this, as it is violative of Article 14, the equality right, it is being invalidated. And another judge, what he said is, it is not a very good law for the reason that it is not in accordance with the Quranic practices. And it took the protection from the theology. So, the fundamental question over here is, does the personal laws come under the scrutiny of constitution or not? These questions are not even addressed today. It would have been a golden opportunity for the Supreme Court to address the same. And then caste and class. Economic differentiation shall be a basis for reservation, or caste base shall be the basis for reservation is a question which was existing from very long duration. Obviously, identity-based politics, vote bank politics have preferred caste as a mobilization factor, and they also have relied on the caste to provide for the reservations on one side. And then there are demands now and then for economic criteria for reservation, and our constitution also has clearly stated that the social and educational backwardness shall be the basis for reservation, not the economic backwardness. But can it be applied same for the subcategorization? So Government of India has recently proposed that there has to be subcategorization among the central OBC list. It means that whatever is being practiced in few states as BCA, BCB, CD, that will also be applied in the case of the union OBC list. Here, the center also has raised the ceiling of the creamy layer to 8 lakh of rupees. So obviously by raising the ceiling, most of the people are going to get benefited from the reservations. And the people who are going to get benefited are relatively rich enough. And the government has given an argument for the subcategorization is like this. It is supposed to benefit the people who never got benefited from the reservations. It means in Uttar Pradesh and Bihar, if Adavas have benefited from the reservation, other subcastes among the other backward classes shall also be benefited. For that, we need this particular section 3, we need this particular subcategorization. Then, can't that logic be applied to the scheduled caste is the second question which comes up. It means the government is going to raise many of the legal, constitutional and social issues through this subcategorization of the OBCs. Is Prasar Bharati is its master's voice? It can be a question for every public sector undertakings. The PSUs today are making losses. They are said to be inefficient, overloaded with people, and they are a burden on the public exchequer. This is what is the opinion we have. So, is the ad stick on which we are measuring the public sector undertakings, is it the right ad stick? Because public sector undertakings are not just created for a profit motive, they also have other objectives. If you take the Prasara Bharati, its primary duty is to inform, educate, and entertain. So here, entertain is only one element. The primary objective is to serve to serve for the integrity of the nation, to build up a sense of respect towards the state and the nation. All these are its functions. And second, though it is created as a separate corporation, it is ultimately controlled by people from Information and Broadcasting Ministry. Most of the CEOs of this are additional secretaries of the government. And the overload which the government has, almost 400 plus employees, these have been dumped on Prasara Bharati. And financial or budgetary allocations are also made by this. And these organizations are thoroughly bureaucratized. Obviously, it acts against the innovation or professionalism in the organization. So at this point of time, providing for autonomy, devolution of power, professionalizing the institution, organization, and bringing in new innovation and expertise are critical for the revival of the Prasara Bharati. And don't fear trade deficit. So the trade, more than the trade deficit, the free trade will provide the benefits. As the trade flows across the borders, it builds good relations. Now, India-China discussions, the trade deficit is almost talked about, and it is unfavorable to India. The reason is, from China, investments are coming in. For India, it is buying the Chinese products. So, on the capital account, India will be positive. On the trade account, India will be negative. So we have to see the holistic, that is, balance of payments picture. That's what this article is trying to say that. Now, again, Supreme Court overrules emergency era habeas corpus verdict. So you have to remember this ADM Jabalpur case in which right to life and liberty are being taken away by the Supreme Court. Supreme Court did not stand for the citizens to protect this. Only one judge who has resented, he is Hansraj Khanna. Later, he lost his Chief Justiceship because he has resented against the government. During emergency time, Article 20 was suspended. Leaders of the opposition are being kept in the jail. Then this ADM Jabalpur case, the Supreme Court is expected to protect the liberties of the people, which it did not do. So in this case, Khanna, who stood for it, he lost his Chief Justiceship. Mr. Beg was promoted in the place of Hansraj Khanna, and he resigned from the Supreme Court as a judge. So the Supreme Court has expressed concern or expressed its concerns with regard to this particular failure of the court to protect the rights and liberties of the citizens. And then, so there are commentaries with regard to the right to privacy, and the LGBT community is cheerful, and protect the privacy of the children, but that is by Justice Kaul. These are the various things we've spoken about. And China slams India over road building in Ladakh. So China is trying to irritate India and wants to play what India did in Doklam at the other places. So in Ladakh, it was objecting to the road which is being built by Border Roads Organization. In the last page, I gave you the notes, and this notes is available to you at laix.in/civilsprep. Thank you very much and all the best.